Hey everybody, big news coming out of Pennsylvania Federal Court in the United States District Court of the Western District of Pennsylvania. A huge opinion written by the Honorable William S. Stickman IV. I will get right out of the way that he was a Trump appointee judge, and all the judges have been appointed who came off a Federalist Society list. So not really surprising to see that this opinion came out. It's 66 pages. I went through it diligently and I highlighted a lot of areas. It's going to be a little bit of a longer video so you can go through it and you can kind of take out bits and pieces of what you want to see or what you want to take note of. But this is a really, really great, there's a lot of great things in this opinion. So all the stuff that I think people have been frustrated about, people have been angry about when it comes to COVID, and these lockdowns and regulations and stuff like that. There's a lot of stuff in this opinion I feel like this judge really taps into. And it really reads as if he's addressing those issues. So for all those who are sitting out there and are frustrated and say, you know, the government doesn't really care, they just keep going through these lockdowns, how does this make sense? I'm going to get into it and sort of the constitutionality and the legality of it, and that's what we're going to get into here. So obviously, 66 pages. I'm not going to go through everything. He does have a little intro talking about how even though the lockdowns and all that stuff are done with good intentions, it's not alone enough to uphold governmental action against a constitutional challenge. Even in emergency, even a vigilant public may let down its guard over its constitutional liberties, only to find that liberties once relinquished are hard to recoup and that restrictions, while expedient in the face of an emergency situation, may persist long after immediate danger is past. I think that line is very good, and I think that kind of hits at the core of what a lot of people are afraid of, sort of with September 11th and the Patriot Act. I saw a meme out there about how this stuff will never last forever. It says the guy who still has to take his shoes off at the airport. That's what I think a lot of people are worried about, is that at a certain point, these constitutional issues, do we ever get the freedoms back? Are we always going to be under this sort of weight of that if COVID ever comes back, or if the next flu or any sort of influenza pandemic comes back around, are we going to be under these lockdowns again? And are we sort of just living in this temporary state where public health officials and public health officers really wield all the power and the rest of the government can't do anything about it? So it goes on to talk about the big thing with this opinion, and I don't want to get too technical, is that there's different levels of what they call scrutiny when it comes to constitutional issues. There's three levels. There's strict scrutiny, there's intermediate scrutiny, and then there's rational basis. So when a court, whether it's a federal court or the Supreme Court, anybody like that is looking at anything involving the Constitution, there's a lot of case precedents talking about these different levels of scrutiny. And it's based on different amendments, different rights, stuff like that. Strict scrutiny, usually everything fails when it's applied to strict scrutiny. Intermediate scrutiny is more about narrowly tailored and a rational basis. Or reasonable purpose with the government, substantial interest. And rational basis is the easiest to pass. Basically, they just have to show there's a rational reason for what they are enacting and what the purpose of the statute is. So the whole opinion gets into that because I've said this before, and I've said this to many people, is that we are in the wild west of law right now, and a lot of constitutional law at that. So there's a lot of stuff that we're sort of figuring out, and even in our personal case against California in the county of San Diego, you have to recognize that they are citing to cases that are actually still just going up through the court system, or that they are not really resolved yet, or they're on appeal. So there's a lot of case law out there that hasn't even really been solidified or gone up to the Supreme Court is what they're citing to. So that's what I mean when I say that this is really the wild west of legal constitutional issues right now, because there's just not a lot of case precedents. And this opinion gets into it a little bit in the fact that this is unprecedented. We've never seen governments act this way, come out with these lockdown measures and these regulations, and this business can open and that business can't open. And that's what he sort of talks about here. We're going to talk about that and get into that. But it really is unprecedented in this sense of stay-at-home orders. You got to stay at home. You're locked down. Are you quarantined, or are you recommended to stay home? Which businesses are allowed to open, which businesses aren't allowed to open, what is life-sustaining, what's not life-sustaining. So a lot of this has never been done before, which is why a lot of these courts are really struggling with COVID right now, because they don't really know how to handle it. And there's just not a lot of precedence on it. They use Jacobson, which is another thing he talks about at length here, about that's sort of the precedent Supreme Court case from like 100 years ago that really just kind of gives carte blanche, or according to a lot of government defendants, it gives them carte blanche to do whatever they want during a public health crisis. But he kind of rips that to shred as well. So there's a lot in here. Going to get to a lot of it. It's going to be a little bit of a longer video. So if you really want to just kind of settle in and this isn't going to be a quick like 5 to 10 minute video. Like I said, there's 66 pages of this, and I want to get through it as much as possible. I picked out what I think is the most interesting stuff and some of the most poignant points that he makes when it comes to all these lockdowns and what he said about Pennsylvania. Now, this isn't really anything to do with California, but because it's federal and it's constitutional, it does tie into what is going around the country. That's the great thing about federal cases, and especially constitutional cases from federal courts around the country, is that they kind of all tie in together because they're all about the Constitution. And by Constitution, I mean they're about a lot of these constitutional cases are stuck on the Constitution. So, having addressed the necessary threshold questions, the court proceeded in the merits of that the congregate gathering limit imposed by defense mitigation orders violate the right of assembly. So these are the things he's going to go over. That the stay-at-home and business closure components of defendant's orders violate the due process clause of the 14th Amendment. And 3, that the business closure components of defendant's orders violate the equal protection clause of the 14th Amendment. So if you want, before I jump in, if you want a too long, didn't watch the entire thing, I'll give you spoilers right now. He basically eviscerates everything. He says that it is an infringement on the First Amendment by limiting people to gather or to engage in the right of assembly. That the stay-at-home and business closures are arbitrary and capricious, especially on the fact that they couldn't really define what is life-sustaining and what's non-life-sustaining, as opposed to big box stores were open, but small retails were not open, even though they're selling the same thing. So he found that was because it's arbitrary and capricious, it doesn't even pass rational basis. Same thing with the business closure components, which is they couldn't really define exactly what was life-sustaining, what was not life-sustaining. And because of that, again, he found it arbitrary and capricious, and that it didn't really have any rational relation to or make any sense as to why could you go to Walmart to buy hair care products or a washer or dishwasher or something like that, but you can't go to a family-run appliance store and buy a dishwasher or washer because one does one, and they couldn't really define it. At least the government defendants in this case, the Pennsylvania could not define it. So he found that all of it was arbitrary and capricious. So that's the too long, didn't watch the whole thing. I'm going to jump into it now. We don't need to go into the background. This is really just talking about really how this all came about. So, similar to what's going around the country, a lot of the meetings coming up with these things were not open to the public, which is a big issue. So we're just going to keep scrolling down. We're going to jump really right into the thick of the legal arguments, because that's what we really care about here is the legal arguments. We don't really care about what happened in Pennsylvania. It's the same thing that's happened all over, regulations, lockdowns, stuff like that. Let's see if we can catch up to me. Giving it a second. We'll skip over that analysis. That's not really that interesting. This is basically doesn't really pertain to what we want to get into. Told you, there's a lot of pages here. So this is really like what I was saying, too long, didn't watch. Plaintiffs base their constitutional arguments on ordinary constitutional scrutiny, whereas defendants argue that their actions should be afforded a more deferential standard as emergency measures relating to public health. That's sort of been the theme of a lot of these government defendants. The same theme in our lawsuit, which is that this is a public health emergency, so government really gets to do whatever we want because we want to make sure we stop COVID-19. And that because of this, the government really doesn't have to worry about infringing on your constitutional rights. They can just go ahead and do what they need to do, all in the name of stopping coronavirus, which is been held up in a lot of places. Even the Supreme Court upheld it, which we'll talk about. And this is really the case that they have been going with. They used it in our case, in our motion to dismiss. It's Jacobson v. Massachusetts. And Jacobson v. Massachusetts, well, it's 1905. That's an old case at this point. A lot of stuff has happened. And they use it, and they have gone back to it, and a lot of the courts have just continually gone back to it. Even the Supreme Court has really gone back to Jacobson to say that whenever there's a public health emergency, government officials, public health officials get to do whatever they want. Well, that's sort of where this judge has issue with it. Same thing we said as well is that, yeah, the precedent is there, but there's also a caveat in Jacobson that you can't just do whatever you want. So the defendants argue that no matter the traditional level of scrutiny that the underlying constitutional violation, so like I was saying, if there's a constitutional violation, there's different levels of scrutiny. There's strict scrutiny, intermediate scrutiny, and rational basis. And it depends on what constitutional violation falls in these different tests. So they say basically, even if we go ahead and violate your right to freedom of religion, which is a strict scrutiny standard, Jacobson basically says you don't have to worry about strict scrutiny. It's a health crisis, and all deference goes to the government. This is just a little bit of history about it. He talks about more and more. We're going to keep going down. And this is the caveat that Jacobson throws in there at the end, but it also is never included with a lot of the government defendants. Judge says here, rather, it closed with an opinion with a caveat to the contrary. Before closing this opinion, we deem it appropriate, and this is from Jacobson, in order to prevent misapprehension of our views, meaning do not misconstrue our views, to observe, perhaps to repeat, a thought already sufficiently expressed, namely, that the police power of a state, whether exercised directly by the legislature or by a local body acting under its authority, may be exerted in such circumstances or by regulations so arbitrary and oppressive in particular cases as to justify the interference of the courts to prevent wrong and oppression. So, basically, as the judge says, there's no question that even in the plain language, a public health measure may violate the Constitution, which is something we also argued as well, is that even though a lot of these government defendants go out there and say, it's a public health crisis, we get to do whatever we want, the Constitution doesn't really matter, we get to throw it out the window, that's not really the case. And Jacobson says it itself, is that at a certain point, if your regulation or what you're doing to stop or mitigate the public health crisis is so arbitrary and oppressive that the courts actually do have to step in and tell the government, whether it's the executive branch or the legislature, to stop. You can't do that, because that's the point of having checks and balances. We have three branches of government. We have the executive, the legislative, and the judicial branch. And this is where the courts really have to start stepping in. And that's what this judge did, and a lot of people are applauding him around the country right now, is that finally a court is stepping in and saying, okay, we really need to take a look at these lockdowns and say, are they arbitrary and capricious? And that's basically he set the tone for the rest of his opinion. As a general matter, this development has seen a jurisprudential shift whereby federal courts have given greater deference to considerations of individual liberties as weighed against the exercise of state police powers. And he's talking about that Jacobson was a long time ago, 1905, and a lot of things have happened. There's been a lot of case law since Jacobson. A lot of things have happened. We've had the civil rights issues have happened. A lot of things in the 60s and the 70s. We've had activist courts. We've had conservative courts. We have a lot of things that have, in jurisprudence, constitutional jurisprudence, that has happened since Jacobson, and really since the rise of what he calls the creation of tiered level scrutiny, which I have mentioned, talked about those three levels. He talks about this is that's just another case that we're going to jump down to. The permissive Jacobson rule floats about in the air as a rubber stamp for all the most absurd and egregious restrictions on constitutional liberties, free from the inconvenience of meaningful judicial review. This may help explain why the Supreme Court established the traditional tiers of scrutiny in the course of the 100 years since Jacobson was decided. In this case, they were talking about the fact that Jacobson, again, government defendants love to use this. They're cherry picking the argument that, well, we get all this deference and we get to do whatever we want because of this public health crisis, and we get to trample all over your constitutional rights. But in a lot of cases, it was kind of come back and say, well, not necessarily. That's why we've created these different levels of scrutiny and how to really look at constitutional violations. And then we start to get into relevant cases, and this is from a relevant case, Calvary Chapel, U.S. Supreme Court case, and Justice Alito saying, "We have a duty to defend the Constitution, and even a public health emergency does not absolve us of that responsibility." And this is from his dissent. "But a public health emergency does not give governors and other public officials carte blanche to disregard the Constitution for as long as the medical problem persists. As more medical and scientific evidence becomes available, and as states have time to craft policies in light of that evidence, courts should expect policies that more carefully account for constitutional rights." So Alito, what he's arguing here is saying, and Justice Alito is a very conservative justice, another Federalist Society judge, he's basically saying that the longer this goes on, we're getting more and more evidence of how this virus, how this epidemic is evolving, and how states really have to start to narrowly tailor more and more based on the science and data that they're seeing, these regulations and these lockdowns. So living in March 2020 land is not permissible under the Constitution in what is September 2020, how many months later. And we have a lot of data and we have a lot of science about how this virus acts, and states really should step back and say, how can we make sure we're doing what we need to do to slow the spread or help the most vulnerable, but also make sure people's constitutional rights aren't being trampled on. And that's an issue that a lot of people are feeling right now, is that we're kind of in like Groundhog Day right now, in the sense that it doesn't matter how much data comes out and how much stuff we know about this or how much we learn about it. It seems that the lockdowns and the regulations continue to be ramped up. So suspension model is the three objections to an overly deferential suspension model standard of review. Principles of proportionality and balancing driving most modern constitutional standards permit greater incursions into civil liberties in times of greater communal need. This is the essence of the liberty regulated by law described by the court in Jacobson. Again, we come back to Jacobson. Finally, the most critical failure of the suspension model is that it does not account for the importance of an independent judiciary in a crisis, as perhaps the only institution that is in any structural position to push back against potential overreaching by the local, state, or federal political branches. Otherwise, we risk ending up with decisions like Korematsu v. United States, in which courts sustain gross violations of civil rights because they are either unwilling or unable to meaningfully look at the government's purported claims of exigency. Quick history lesson, Korematsu v. United States is actually still good law. It hasn't been repealed. Korematsu was the United States Supreme Court case that said that, and this was back during World War II, that it was okay to forcibly remove Japanese Americans and put them in internment camps during war. And that their argument was based on, because it's war, because there's an emergency going on, we have to protect national security. And what this is arguing, again, is that same thing we argued in our lawsuit when it comes to policy. Courts have to step up at some point. Maybe in the beginning, maybe in March or April, May, we didn't really know too much about what was going on with COVID. But at this point, we really know what's going on, and courts kind of have to step in. And that's why I think this judge, he's seen enough evidence, he knows more about it. And at this point, I think he's probably trying to say, well, he's exactly trying to say that the courts and the judicial branch have to step in at some point. And that's the policy argument we made, is that when it gets to a point where your regulations are arbitrary and capricious and oppressive, courts have to step in because they have to protect the Constitution. So that's sort of that's what that is saying. Again, he talks about and this is why I said this is basically for everybody who's frustrated. It sounds like he's really voicing their concerns. What were initially billed as temporary measures necessary to flatten the curve and protect hospital capacity became open-ended ongoing restrictions. And basically, now it's gone from flatten the curve to we have to stop all positive cases. So, and then he talks a little bit about how they say this is the new normal and that there's really no plan to go back to normal. And there's a little bit of witness testimony. We're going to keep jumping ahead. Oh, want to go back there because there's an exclamation point. So going back to Justice Alito, the courts may provide state and local officials great deference when making time-sensitive decisions in the maelstrom of an emergency. But that deference cannot go on forever. It is no longer March, it is now September, and the record makes it clear that defendants have no anticipated end date to their emergency interventions. Faced with ongoing interventions of indeterminate length, suspension of normal constitutional levels of scrutiny may ultimately lead to the suspension of constitutional liberties themselves. And that is huge. Because if that's how the courts are going to approach this, that basically, again, I sound like a broken record, but that's really at the heart of all these issues, whether it's business closures, whether it's quarantine of the healthy, whether it's a mass lawsuit. It's the issue of how far are we going to let public health officials go? How much power are we going to give them to trample on your constitutional rights? And if there's no end in sight, how long is the emergency actually going for? How long can they legitimately say there's still an emergency when we know all the data and the science of how to prevent this and how to slow the spread without being overburdensome? And he's basically saying that if we allow, and this is a slippery slope, if we allow this to keep going and we allow the courts to just basically say, well, we're hands off and they get to do whatever they want as long as there's a public health crisis, pretty soon it's just going to be they can trample on constitutional liberties altogether. And this is something else, same thing. Again, the judiciary cannot abrogate its own critical constitutional role by applying an overly deferential standard. Something we've argued as well in our lawsuit is that you cannot just be hands off. You are part of a checks and balances system. And he talks a little bit about the founders and about how they they hated a one-person rule. Obviously, they fought against the king, absent a robust system of checks and balances. Basically the same thing. You cannot allow, just because it's a pandemic, we can't just throw our whole constitutional system in the garbage. And the Constitution was adopted in a period of grave emergency. Its grant of power to the federal government's limitation of the power of states were determined in light of emergency, and they are not altered by emergency. So that's another U.S. Supreme Court case. Okay, so getting there slowly. Like I said, this wasn't going to be a quick one. I want to get through some more of these points. I like this little footnote. The immediate case, however, is really distinguishable. And this is basically addressing the fact that, there's an emergency, so we get to do whatever we want. But now there's a benefit of a developed evidentiary record, which includes specific reasoning and testimony from the parties. So at this point, there's a lot going on. There's a lot we know. There's a lot of science out there. So this one was pretty interesting, and I think this would make everybody happy, is they called out in this lawsuit, and the judge is effectively calling them out as well, the issue with protests. So they limit the amount of people who can get together, whether it's assembly for church or political gatherings or campaign rallies or anything like that. However, they seem to be fine with protests. And he calls out the plain language of the orders make no exception for protests, which seemingly run directly to the plain language of the May 27, 2020 order. However, the record unequivocally shows that defendants have permitted protests and that the governor himself participated in a protest which exceeded the limitations set forth in his order and did not comply with other restrictions, maintain social distancing and mask wearing. And this is what you would call a content-based what is effectively a content-based restriction, is that on one hand, if your content is political or religious, that's banned. But if you're protesting for a certain message, that is actually also, that's based on content, the content of your gathering. So it's content-based. And he goes on to talk about content neutral. I don't want to get too far into that because that's really getting in the weeds. A lot of these highlights are for myself because I thought this was a great ruling, but there's some other things I want to get into. So he called out the protests. He called out the defendants for not really applying them evenly. And again, he does it saying that they have made the limited exceptions for those constitutionally protected speech, such as protest, and the individuals have the right to protest and demonstrate. Defendants cannot govern by comment. Rather, they are bound to the language of their orders. Those orders make no allowance for protest. As such, the orders apply to expressive gatherings across the board. To that end, they are content neutral. So basically, he's calling them out in their hypocrisy and saying, on one hand, you say that everything is content neutral, but then you go out and you allow protest. He goes on to talk about more content neutral. And then we talk about intermediate scrutiny. Intermediate scrutiny. So again, you have those three hierarchies. You have strict scrutiny, intermediate scrutiny, and rational basis. Strict scrutiny being the toughest, usually never passes unless it's national security. But intermediate scrutiny is narrowly tailored to serve a significant government interest and leave open ample alternative channels of communication. The Supreme Court explained that the requirement of narrow tailoring is satisfied so long as the regulation promotes a substantial government interest that would be achieved less effectively absent the regulation. Again, narrowly tailored is something we argued in our mass lawsuit, is that you have to, if you're going to come out with a regulation or order, it has to be narrowly tailored to the point. And you have to show that what you're doing has a substantial government interest and that you can't just arbitrarily make up orders and say, well, it's based on this rational belief. No, it's more of an intermediate scrutiny. Additionally, a statute is narrowly tailored if it targets and eliminates no more than the exact source of the evil it seeks to remedy. And he keeps going on and on. He talks more about how the hypocrisy. I want to get into the business arguments. This was pretty interesting. He called out the Lard Pruos test after featuring numbers far in excess of the outdoor limit. Even though their whole reason was to stop mega spreading events, but when asked about protests, they kind of didn't really say anything about whether a protest was a mega spreading. And getting through. Told you this is a long. Okay, this is a great line. If social distancing is good enough for Home Depot and Kroger, is good enough for in-person religious services, which, unlike the foregoing, benefit from constitutional protection. Something people are always saying, if you can stand in line at Home Depot and Kroger, or where you can go vote, or you can go to church. So, again, a lot of the frustration I think people are feeling is really borne out in this opinion. Now he talks a little bit, we get into the stay-at-home orders. Hope you're still with me. So he talks a little bit about the initial stay-home order had an expiration date, like we all were all told, 15 days to flatten the curve. That's why we all stayed home, why we're all staying home, watching Joe Exotic and enjoying our stimulus checks. But now it got to a point where there is effectively no end date. And they try to say, well, it doesn't really matter now because we've suspended the stay-at-home requirement. And he calls it out and says, well, that's a clever play on words, but a suspension is not a rescission. And you see that here in California. This idea that, well, we moved into you can open or you can maybe not open, but if the numbers go up, well, we got to close you down. That's sort of this back and forth. So it's always lingering out there. And while the defendants are trying to say, well, it's kind of moot at this point because there is no stay-at-home order, it's just been suspended. So it's in the background. And it could still pop out at any time, and that doesn't really change the fact. We're going to go more into it. He talks more about how your personal liberties should not be infringed when there can be more narrowly achieved. And then they try, this was pretty cute. The defendants try to say, well, they're merely recommendations. Judge calls out, says that's BS. The plain language of the order shows that these provisions were mandates. Further, the record contains evidence of citations issued to Pennsylvania residents for violating the orders. So they tried to be cute. They tried to say, well, it's moot because it's not really happening, even though they found out it was suspended. And then they were trying to say, well, it's only a recommendation. It's not really an order, which the judge called him out for that and said, no, actually, it was an order based on the plain language of your order. Gonna keep going through. Like I said, there's a lot of highlights here just for myself. So this is, again, what you were talking about, the secession doctrine, the secession idea. So in law, you can dismiss a case when it's moot, when something is no longer applicable or there's absolutely no controversy anymore. So effectively, you'd be litigating something that even if you came to a ruling, it doesn't change the outcome because it's already over at that point. So the defendants are trying to argue that the stay-at-home order is moot because they have suspended it or it doesn't apply anymore. Judge, however, calls them out and says, well, just because you stop doing the activity yourself, it doesn't mean that it's moot. And it's this voluntary secession doctrine is an exception to mootness. And what that means is, so if I sue you for something because you're doing something wrong and I'm asking the court to make you stop doing that, if you stop doing it as soon as the lawsuit happens, a lot of times courts will say, well, just because you voluntarily stop doesn't mean we're not going to litigate it, because if we dismiss the lawsuit, then you could just go back to doing what you're doing. It could be this back and forth. It's not efficient. We got to keep going back to envisioning the same thing. So that's what these defendants are trying to argue, is that it's moot. But the judge is saying, well, no, you say it's moot, but it's only moot in your eyes because you voluntarily stopped doing it after the lawsuit. And just because you said, well, we don't do the stay-at-home order anymore, that doesn't mean that we still can't tell you you can't do the stay-at-home anymore. So basically, the court is putting on notice saying, we know that you can reimpose it at any point. And that's this highlight. Thus, when a plaintiff seeks declaratory relief, defendant arguing mootness must show that there is no reasonable likelihood that a declaratory judgment will affect the party's future conduct. So basically, if they say, well, you don't have to decide on this because we don't do it anymore, then they dismiss it. And then all of a sudden the state of Pennsylvania goes, well, we're going to order everyone to stay at home again. That would recreate a whole nother lawsuit. They got to bring it all back. They got to do all the work again. And it just becomes an issue. So that's why the courts don't let it happen. And that's why he's not letting them slide on this. Again, he calls out the governor can move back to restrictive measures at will. So basically, even though they say they're not enforcing it right now, doesn't mean that they can't do it again. And this whole argument about suspended. So they're trying to get around it by saying, well, it's suspended, but that doesn't mean they can't just go back to it at a later time. Same thing. Like this highlight, more of the specter of future reinstated lockdowns remains a concern for plaintiffs and continues to hang over the public consciousness. This whole area is talking about how broad lockdowns have never, ever been done in American history. Even if there was a quarantine, it was limited to a period equal to the longest usual incubation period of the disease. And the lockdowns went way past that, because even if it's 14 days, we've gone way past 14 days. And they try and always argue about the Spanish flu, but even the Spanish flu didn't have anything close to this. Going through. And then they try and argue why they can lock down businesses. While unquestionably states and local governments restricted certain activities for a limited period of time to mitigate the Spanish flu, there is no record of any imposition of a population lockdown response to that disease or any other in history. We've never done this, basically, point blank. We've never done this, and we don't know why we're doing this. CDC recommends voluntary home isolation, so the CDC hasn't even said that lockdowns were the way to go. And we talk about it a little bit more. But I really want to get to the business closure, because the lockdowns at this point are, in a sense, kind of moot. But just keep in mind that whole idea that just because they've suspended them doesn't mean that governments won't try and make you go back to staying at home again. I like this one because we argued this in our complaint. Our courts have long recognized that beyond the right to travel, there is a fundamental right to simply be out in public. So that's part of your right, to just be out and about. That's one of those intrinsic rights. The freedom to leave one's house and move about at will is the very essence of the scheme of ordered liberty. and hence is protected against state intrusions by the Due Process Clause. It goes on to talk about walking around. Trying to get through this. I don't want this to be super long, but I mean, there's a lot here. And I think if you really want to nerd out on it, there's a lot of stuff to get into here. There's a lot of meat here. I mean, for any attorneys around the country who have been fighting out stuff like that, like this, like us, for example, this is like manna from heaven. This is an incredible opinion on the sense of basically all the arguments we're making. So for a judge to put it in an opinion is great for attorneys like us who are arguing a lot of cases like this. So now we get to the business challenges. And basically he says the same thing. We've never done this before. And the same exact response. The business closures were never rescinded. They were just merely suspended. So that whole idea that same thing here in California, which is you could reopen, but there's sort of this suspension of, well, it's hanging over your head that they could lock down at any moment. And that's what really kind of infringes on your right. So even though they say, well, we've allowed places to open, it doesn't mean that they can't just turn around and say, well, you're closed down again. They talk a little bit about the basic rights to engage in common occupations of life and engage in the pursuit of his or her chosen profession, free from unreasonable governmental interference. That's sort of what the 14th Amendment guarantees. Keep going. We're going to talk about this. And it keeps talking about the right to work. And this quote right here, the Constitution only protects this liberty from state actions that threaten to deprive persons of the right to pursue their chosen occupation. State actions that exclude a person from one particular job are not actionable in suits brought directly under the Due Process Clause. Is the liberty to pursue a calling or occupation, not the right to a specific job that is secured by the 14th Amendment. So I want to get into this. He talks a lot about the businesses. A total shutdown of a business with no end date and the expector of additional future shutdowns can cause critical damage to a business's ability to survive, to an employee's ability to support him or herself, and adds a government-induced cloud of uncertainty to the usual predictability of nature and life. And that's, again, what we're seeing is this whole open, shut, open, shut, open, shut. And this businesses can't really stay on top of it. They can't operate. They can't pay employees, they can't keep the doors open, they can't invest. So this idea that, and we've seen it here in California, we reopen, then we close, then we reopen, and now we're in this weird color-coded system that if one county goes up, you could be shut down again. So it really kind of throws a lot of businesses and deprives them of their right to make a living. One of the plaintiffs lost $300,000 in revenue. He's been financially devastated, he says. Another plaintiff lost $150,000. They depleted their entire emergency fund. It matters, and this is a great line, it matters little to a business owner or employee that defendants intended for the restrictions to be temporary. Again, just because you can take all your sorries and stuff them in a sack, your intention that it was only supposed to be temporary does little to quell the fears of them or make them feel better about the fact that their business is falling out from under them. Again, the touchstone of due process is protection of the individual against arbitrary actions of government. And this is what I've been talking about. Conversely, actions with irrational, arbitrary, capricious do not bear a rational relationship to any end. So that's how you get past rational relationship or rational basis, even though rational basis is usually the easiest, but if it's arbitrary and capricious, the court will strike it down. He goes into a whole thing about how the defendants could not classify what is life-sustaining, what's not life-sustaining, because that's how they classify what could be open, what could not. And they didn't really have a definition. They just basically threw up their hands and said, well, we thought everyone would assume. And he really hammers them on that whole thing that you couldn't even apply for a waiver. So even though, this is a good one, despite the fact that the decisions had the potential, in many cases, the actual effect of destroying businesses and putting employees out of work, defendants and their advisors never formulated a set objective definition in writing of what constitutes life-sustaining. And this is where he calls out the hypocrisy that you couldn't go to a small appliance or furniture store because they were deemed non-life sustaining, but you could go to a Lowe's, a Home Depot, or Walmart. So basically the same thing. You could go to these big box stores and get what you wanted, but you couldn't go to a small appliance store. But he keeps going on and on and on about, you're right. Another good point he made is the fact that, let's see if I can find it, because there's a really good point. As stated above in the reference to business plaintiffs' due process challenge, to the extent that defendants were going to exercise an unprecedented degree of immediate power over businesses and livelihoods, to the extent they were going to single-handedly pick which businesses could stay open and which must close, to the extent that they were picking winners and losers, that they had an obligation to do so based on objective definitions and measurable criteria. This is talking about the Equal Protection Clause, picking winners and losers. And so, here it is. So basically, this is the last point I want to make, is he said that, because we're coming to the end of the opinion anyway, he basically pointed out, again, the hypocrisy of this is that they say, well, we had to quantify life-sustaining and non-life-sustaining because we were trying to make sure we slowed the spread. But the problem with that is, and a lot of people I'm sure know this, is that by closing all these smaller retails, you've effectively sent everybody to the same exact location. So if you're trying to slow the spread of something, you'd want to spread people out, correct? So if you wanted to go to a small appliance store as opposed to a big box store, you could go there and people could spread out where they have to go. But instead, in the beginning, they were effectively forcing everybody into Walmarts or grocery stores and everything like that. And people were all jam-packed into these small stores. That's the only place they could go. So his argument is that while they're trying to say, and this is the defendant Pennsylvania, is that they're trying to say they were limiting personal interactions, it did the exact opposite. It forced big groups of people together into these stores. So it irrationally did not have the purpose that they were looking for. And because of that, it was arbitrary. Okay, final thing, his conclusion is fantastic. The liberties protected by the Constitution are not fair weather freedoms in place when times are good but able to be cast aside in times of trouble. There is no country that this country has faced and will face emergencies of every sort, but the solution to a national crisis can never be permitted to supersede the commitment to individual liberty that stands as the foundation of the American experiment. The Constitution cannot accept the concept of a new normal where the basic liberties of the people can be subordinated to open-ended emergency mitigation measures. Rather, the Constitution sets certain lines that may not be crossed even in an emergency. And then he goes on to say that the actions were unconstitutional, and they entered judgment in favor of the plaintiffs. So again, this is a big 66-page opinion. A lot's in there. I tried to pull out the most important facts. Again, the facts that you want to remember, the arguments you want to remember is that there's these different levels of constitutional scrutiny, that a lot of these things are, at this point, arbitrary and capricious, maybe over-oppressive. A lot of things that we thought back in March no longer apply now in September. So for a lot of these reasons, now that we're looking backwards, the most important point I think I can make is that courts have to step in at this point. And courts have to start looking at these cases and taking them seriously. Even the Supreme Court at this point, because this is most likely will get appealed to the next federal appeals court, and then we'll see where it goes from there. But at this point, I think courts have to start stepping in and coming out with these rulings, because it gives the people, it gives governments, it gives people the notion that there is checks and balances and that the courts are watching and they have to step in and they have the power to step in and tell these governments, you've gone too far. Now you got to bring it back a little bit. So with that, thanks for watching. Thanks for sticking with me if you stuck with me for the whole 44 minutes. If I have any more updates, I will let you know. Thanks again.